Good evening, everybody. I'm delighted to welcome you to the second of this year's Readers' Lectures. Now, yesterday was International Women's Day, and what could be a more appropriate topic for this evening's lecture than the contribution of women such as Caroline Norton, Barbara Bodichon, and Frances Power Cobb to the passing of the Married Women's Property Act in 1882, an act which, as we'll hear, had an important and lasting effect on women's rights over their property. Our lecturer this evening, Dr. Andy Hayward, is an academic bencher of the Inner Temple and associate professor at Durham Law School, teaching primarily family law and equity, and his research interests cover a wide range of legal regulation of adult relationships, including domestic and comparative law, reform in relation to civil partnerships, and development of the law of common intention constructive trusts and proprietary estoppel in the area of cohabitation and the family home. He's recently advised the Equalities and Human Rights Committee of the Scottish Parliament on their forthcoming bill to reform civil partnerships. Dr. Hayward's work at Durham has included the establishment of the Sir Andrew Macfarlane Prize in Family Law, which rewards the top 3 students with marshalling opportunities in the Royal Courts of Justice. And he's been the recipient of the University Excellence in Learning and Teaching Award. But not content with the beauties of Durham, which are many, Andy has been a visiting academic at the University of Cambridge, at the Université Catholique de Louvain, and in the Comparative Law Institute at the Université Jean Moulin III in Lyon. So I'm sure that we'll have a fascinating lecture this evening. At the end of the lecture, there'll be time for some questions before the reception. So please welcome Dr. Andy Hayward.
Thank you very much for the kind introduction, and thank you all for coming this evening to this Inner Temple lecture. It's an honour to be an academic fellow working with the Inner Temple and promoting the objective and missions of the Inn up north in icy Durham. Now, the impetus behind my presentation today is to reflect upon and also to celebrate some key centenaries for women. So 2 years ago, we had celebrated the centenary of the representation of the People Act 1918 that gave women the vote. And then last year marked 100 years of the Sex Discrimination Removal Act 1919 that enabled women's entry into the legal profession as solicitors, barristers, magistrates and judges. Now, at face value, both developments were branded as equality measures and were seen as ways of recognising equality of the sexes. Now, the development I want to focus on this evening happened, or had its centenary a few years before, but nevertheless was an act that has very strong connections to those previous 2 acts I mentioned. Indeed, many of the prominent voices that were lobbying for suffrage and also for campaigning for access to the professions were individuals inextricably linked to the 1882 Act. And that's the act I'm going to be exploring, the Married Women's Property Act 1882, which gave all married women the ability to acquire, hold, dispose of property brought by her to marriage or acquired subsequently thereafter as a single woman without the intervention of a trustee. Now, the effect of this particular act was to entrench the concept of separate property and to dismantle many of the disadvantages that stemmed from the common law doctrine of unity of person, which saw husband and wife as one person. Unsurprisingly, that person was the husband. Now, widely considered a key legal landmark, the Act has been lauded as a great victory of the principle of human equality over the unjust privilege of sex, and even as the Magna Carta of women's liberties. However, focusing on the vexed issue of how you regulate property holding within marriage, which is my research area, I really want to interrogate those claims in this lecture and question whether this act which forms the basis of property holding today, still has resonance in spite of, as I'm sure you're aware, the Matrimonial Causes Act 1973 and the discretion that that act confers when it comes to the division of assets. More specifically, I want to explore the concept of equality that is a key feature in the division of assets and the ways in which it has been weaponized, celebrated, and actually undermined over time. Now, to be perfectly clear, I fully support equality, and I personally don't think that it's wild or ridiculous. But this paper is all about trying to analyse the darker side of equality and to explore its multiple meanings and manifestations. I also want to cut through some of the self-congratulation, the pageantry that we often see from generally male legal historians and academics and commentators of the time when they talk about these developments. After all, it should be noted that the Representation of the People Act, 1918, only gave women over the age of 30 with property the right to vote. And similarly, the Sex Discrimination Removal Act 1919 included several restrictions that actually prevented full entry into the profession. And as you'll see from this lecture, the Married Women's Property Act 1882 was exactly the same. So this paper is going to be divided into 3 parts. Part 1, I'm going to look at the pre-1882 position. And I'm going to be looking here at the nature of property holding within marriage, and in particular, the focus on the pervasive doctrine of unity of person. The second part will analyse the aftermath of the 1882 Act and actually endeavours by the courts to mitigate this newly created concept of separate property. And then the final part analyses how equality finds expression today in the modern law in the Matrimonial Causes Act 1973, as interpreted by key House of Lords decisions, notably White and White in 2000. Now, the argument advanced in this paper is that in the sphere of division of assets, where we see competing claims of moral and legal entitlement, equality finds expression really in 2 ways. On the one hand, we have equality as an aspiration, as an ideal, as a driver, as something that is used to fight discrimination. But then also, particularly with the division of assets, we see equality in a different way, and that's as an outcome. The idea of equal division, sharing, or the sharing of the fruits of the marriage partnership, whether it be through a sharing principle or the application of a community of property rule mandating sharing. Now, of course, these are not mutually exclusive. If we think of White and White in the House of Lords, the non-discrimination principle that Lord Nichols created was inextricably linked to the sharing principle, notably the yardstick of equality. But what I want to see is, or argue really, is that equality, particularly just after International Women's Day, is a fluctuating and fragile concept. And sometimes that aspirational commitment to equality needs to be topped up so as to realise equality's true potential as an outcome, as something that is tangible. So any discussion of the Married Women's Property Act has to start with the common law doctrine of unity. So this was premised on the ecclesiastical notion that marriage involved 2 souls in one flesh. And it regarded that the wife changed her status from a femme sole to a femme couvert. In legal French, the wife became essentially covered by her baron. And this religious understanding of marriage also was clearly linked to the church. Civil marriage was only introduced in this jurisdiction in 1837. Now, as will be explored shortly, the implications of the doctrine of unity were very much profound. In a general sense, all of the wife's personal property, whether acquired before or after marriage, vested in her husband absolutely. And this would include any earnings that she made. And you'll note that earnings were really a key battleground in the campaign for the Married Women's Property Act. In relation to freehold, the husband obtained the right to manage the property and to any income that was generated. And then equally with leasehold property, the husband had the right to rents and profits. Now, as a direct result of these impediments of the doctrine of unity, this meant that wives could not enter contracts in their own name. Any that they entered into would be void, unless there was a regional custom that permitted them to trade in their own name as a single woman. And also what happened is if she wanted to litigate a contract, she had to be joined by her husband, and he would be part of the proceedings. Interestingly, if a married woman wanted to purchase something, then she would have to essentially pledge her husband's credit. And this often left shopkeepers quite puzzled and having to delicately inquire as to the status of their marriage, just to make sure that down the line the husband will actually pay for the goods that she's just purchased. And equally, if a tort was committed against the wife, then the husband was the one that had to issue the proceedings, and any damages that were actually received, he owned. And interestingly, and an implication which I don't think was fully thought out by the men who created the Doctrine of Unity, if the wife committed a tort, it was the husband who had to pay the damages. Now, the rationale of this has been widely discussed by the legal community, and it's also been romanticised by legal historians. So obviously, William Blackstone, in his commentaries of the law of England, remarks how the doctrine involved suspension or incorporation of the wife's legal existence into that of the husband. And he was saying that this was really about the wife's protection and benefit, because so great a favourite is the female sex of the laws of England. Pollock and Maitland also note that the doctrine involved profitable guardianship over the wife and her property. And then Glanville Williams, writing at the beginning of the 20th century, even called the doctrine an instance of humanitarianism. But we see exactly what the messaging was of the doctrine, and that comes out quite nicely of the Cornish and Clark quote. It was a vision in comfortable harmony with the wider idealisation of woman in her separate sphere, pure, ladylike, adorable, and in consequence unfitted to the affairs of the world, the management of wealth, or the life of the mind. Now, more recent academic discussion on this issue has questioned whether or not the criticism of the Doctrine of Unity has actually been exaggerated. In a recent article questioning whether modern marriage was still patriarchal in the wake of the campaign for equal civil partnerships, Rebecca Probert and Joe Miles talk about how we're often confronted with the idea that the wife became the husband's property. And that really wasn't true. Also, they note that the true extent of control of the husband over the wife needed to be nuanced. Freehold property, for example, did not become the husband's absolutely, but was managed him during the life together. And if the wife wished to sell her real property, she would need to levy a fine in the Court of Common Pleas and be interviewed separately so as to check to see whether or not there was any coercion. And furthermore, they also note that the Blackstone account, first published in 1765, overlooked the fact that by that point in time, the Court of Chancery had actually no problem in recognising a separate estate of a wife in equity. And this property could therefore be settled to trustees in a manner that actually recognised the wife's separate estate, her separate property. Now, of course, this is true, but we still have to recognise that the doctrine was pernicious and structurally embedded inequality for a variety of reasons. Firstly, the doctrine was for life. Marriage was conceptualised during this period as a lifelong union, and divorce laws, as I'm sure you're aware, were hardly liberal. The earliest option, parliamentary divorce, and this was really the first type of divorce. Henry VIII's divorces were not divorces, they were annulments. The first divorce, which was parliamentary divorce, first used by Lord Roos in 1670, was a really cumbersome process. It required the obtaining by the husband of a decree of judicial separation from the ecclesiastical court. It also required a successful tort claim for lascivious or criminal conversation brought by the husband against the man who had committed adultery with his wife. And then once he's pocketed those damages from that particular tort action, he was then able to bankroll a bill introduced into Parliament to secure his divorce. Now, it's unsurprising that these were incredibly rare, and they belonged to the aristocracy. Hardly any women used parliamentary divorce. The position improved naturally following the Matrimonial Causes Act 1857. And that particular act transferred the jurisdiction over divorce to a secular court, but the position here was hardly equal, because with adultery being the sole ground for divorce in this period, It was only available to the husband to claim damages against the adulterous co-respondent. And whilst the husband could petition solely on the basis of adultery, the wife had to show adultery plus. She had to show an aggravating factor, and these are colourful, to say the least. They included incest, sodomy, bestiality, cruelty, bigamy, or desertion. And this inequality remained in the law until 1923, when we equalised access. The second reason why the doctrine was pernicious was also that it applied in an automatic fashion. The reason being that there were marriage settlements and they could be actually created, but these were clearly the province of the rich. And it's also questionable why they were created. Were they created to protect women, or was it more about a father wanting to protect his daughter's inheritance from a roguish husband that she might marry? And then reinforcing this particular concern, we have a device that was created and attributed to Lord Thurlow called the restraint upon anticipation, or the restraint on anticipation, which was inserted into marriage settlements so as to prevent the wife alienating or charging her separate property and averting the risk that the husband might kiss or kick the property out of the wife. Now, for those without the benefit of a marriage settlement, the common law recognised a claim to dower, a life interest in 1/3 of the husband's real property, but this could easily be sidestepped by the husband placing his property in the hands of third parties. There was a common law right to be maintained, but this was subject to the husband's estate and condition, and you'll be surprised how many husbands this period actually were penniless. So even when the husband predeceased the wife, and thus the wife was entitled to return of her property, previously administered by the husband, even this return wasn't actually absolute. She was entitled to her paraphernalia, her clothes and her jewels. But we have a lovely quote from Lord Keeper Finch in Lady Tyrrell's case of 1660, saying that this wasn't absolute, because she shall not shine in jewels, whilst the creditors in the meantime starve. So where does the Married Women's Property Act 1882 fit within this? So first of all, we have these impediments faced by married women. And as a response, we had a campaign in the early Victorian period. Although there is some evidence of litigation in the Tudor period by married women. Now, what's interesting is with this activism and this campaigning is how equality arguments were being used, how they were being deployed, discussed, and perhaps more interestingly, being ignored by leading feminist thinkers. Now, the primary impetus behind all of this was protection of earnings. Under the common law, the wife's earnings belonged absolutely to the husband, and they could be seized at any moment by the husband. And one account putting forward a Married Women's Property Bill talks about how women had worked from morning till night to see the produce of their labour squandered by a husband in a gin palace. Now, it's largely a combination of key women of the period, high-profile, wage-earning women such as Sarah Siddons and also later Caroline Norton, that we start to see general momentum for change. And in particular, it's the litigation associated with Caroline Norton that really brings this issue to the fore, so much so that she very nearly brought down the government. Caroline became estranged from her husband, George, who was a somewhat unsuccessful barrister, in 1836. He was a drunk and a jealous man and mentally, physically abused his wife. But more importantly, he used the common law as a mechanism to actually claim Caroline's earnings. What she did was equally use the common law in response. She racked up huge debts, pledging his credit. What then happened was that Norton issued proceedings for criminal conversation against the then Prime Minister, Lord Melbourne. And this resulted in a jury throwing out his claim, but it ultimately tarnished his and Caroline's reputation in society. But for me, what is most interesting about this litigation, for this lecture, is how equality is being conceptualised by Norton and among women activists at the time. Now, at that point in time, the word feminist wasn't being used, but it was clear that there was a women's rights movement that was developing, and they had objectives that could be identified as feminist today, although whether they'd be first wave, second wave, cultural, or even radical feminist is disputed. Now, Caroline Norton's perspective is quite interesting, because in a letter to the Queen on Lord Cranworth's Marriage and Divorce Bill, published in 1855, she penned a very powerful plea asking for the removal of legal impediments to Queen Victoria. However, what is really noticeable about this letter is her repudiation of equality. She did not believe in it. What she says is that the natural position of woman is inferiority to man. Amen. That is a thing of God's appointing, not of man's devising. I believe sincerely as part of religion, and I accept it as a matter proved to my reason. I never pretended to the wild and ridiculous doctrine of equality. Likewise, another influential writer at the time, Francis Power Cobb, again rejected equality-based arguments. A man and woman are parallel to each other, but never similar. They are equivalent to each other, but never equals. All these differences are innate, unchangeable, eradicable. Now, what does this tell us about feminist agency during the early Victorian period? Well, what Rosemary Opmuty has argued in her research is that we have to be very cautious about retrospectively looking at the campaign for married women's property through the lens of liberalism. These acts were not equality measures in the modern sense, but they are nevertheless very important for a variety of reasons. To my mind, they were really about simply removing impediments. And within that, the virtue that comes from them is actually this collective strategizing of women. It sounds very bizarre today, but a bold call in 1850 for equality, that we should be treated equally to men, would be too ambitious, too controversial, and potentially something that women even then didn't actually believe. We see this through the writing of Barbara Lee Smith, later Beauchamp. And writing in 1854, she actually produces a short 18-page pamphlet, snappily titled A Brief Summary in Plain Language of the Most Important Laws Concerning Women, together with a few observations thereon. Now, this pamphlet was accessible, and unlike Caroline Norton's plea and impassioned call for assistance, calmly depicted all of the impediments faced by married women. And the interesting thing here was the way in which satire and irony was being used. What really was happening here was that they were trying to show the absurdity of the law without actually saying that the law was absurd. They wanted the reader to get that point, but without the sensationalism, the emotion that we see in Norton's letter. However, there are others that still use irony and satire differently. Caroline Norton remarked that I am Mr. Norton's inferior. I am the clouded moon of that sun. And she later noted the biblical idea of the wife shining in the rays of her husband. And then Francis Power Cobb also uses this, where she attacks the marriage service in the Book of Common Prayer, noting that the husband does not endow his wife with all of his worldly goods. If anything, he actually takes them from her. Now, these devices were very effective and helped galvanize the movement for reform. Indeed, the Beauchamp pamphlet was given to the Law Amendment Society, and the collation of the information underpinning the pamphlet really pushed forward the campaign for married women's property. She spoke to women who were victims of the common law doctrine and tried to use their case stories and their histories. So how did the law actually change? Well, early legislative time was spent with two bills, the first introduced by Lord Henry Brougham, another by Erskine Perry, and the second bill, the Erskine-Perry bill, passed to the second reading. Now, just like equality measures that we talk about today, it's quite interesting because Perry's bill was very radical. He wasn't just arguing for separate property, like the 1882 Act created, but that the wife should be able to act as if she is a single woman, full stop. We have some wonderful, colourful parliamentary debates here, where you have examples of drunken husbands deserting wives, then returning to seize their assets. But nevertheless, we still have some interesting curmudgeonly characters. And so there's a wonderful quote from Sir John Buller saying that women should not be having this access to property because in a frenzy, they will foolishly invest in worthless railway shares or some unsound speculation. Now, by this particular point in time, the time for reform wasn't really right. The Matrimonial Causes Act, 1857, had just been enacted, and these had actually given some protection through divorce. Women could escape the effects of coverture. If they were happily married, she didn't need protection, and if she was unhappy, she could divorce, although remember the unequal grounds for divorce that we had. Now, the next key development was the Married Women's Property Act of 1870. That enabled women to hold property for her separate use, but this was limited to her earnings, savings, bank deposits, or real personal property inherited through intestacy. Now, it was really the bill that was introduced and really shepherded by Lord Selborne that became the Married Women's Property Act of 1882. Now, we had, just before that point in time, a change in the government. We had a Liberal government. And so Shanley has talked about how the passage of the bill actually lacked the drama and suspense of the earlier debates in this area. Nevertheless, we still have, again, these curmudgeonly characters. Sir George Campbell lamenting that the women writers had been exceedingly energetic, so much so that the case for the poor married man was hopeless. Now, with the advent of the new Act, the 1882 Act, I want to reflect on this development and consider what it tells us about equality. Now, first of all, it's an exaggeration to say that the Act ushered in an immediate change or brought to fruition a social revolution that many of the opponents of the Act feared. The Act was actually really something that perpetuated the status quo because even though it looked interesting, it was couched in languages of change and progression, yet really didn't change that much. But often we see that it's a celebration of the Act. We see it as a triumph of equality bestowed upon women for the benevolent kindness of men. Now, there are several reasons why we should be a little bit sceptical as to the equality of the 1882 Act. Well, first of all, we have to work out who it actually benefited. So it has been celebrated as a victory for all women, and to an extent that is perhaps true. So Kenny talks about it and says how the Act gave the mangle, the teapot, and the sewing machine the same protection which diamonds and consoles, consolidated annuities, had always purchased for themselves in the teeth of the law. So the Act did actually clearly give control over to a wider range of women. But the difficulty here, and this is what happens when we have formal equality versus substantive equality, very few women actually had property to retain. So in many ways, the measures of this particular Act, based and justified on equality, is perhaps more significant because of its symbolism, the opportunity, and what could happen in the future. The Act was also heavily caveated as well, and this is easy to discern when you read the small print of it. So Section 19 of the Act meant that all the marriage settlements could still be created, and indeed the restraint upon anticipation could also be still created and inserted into marriage settlements. Also, we find that the Act was then repeatedly amended, 1893, 1907, 1935, 1962, 1969. And this perhaps shows that the equality that was meant to come out of the 1882 Act really wasn't achieved at that point in time. It came later. Also, the terminology of the Act is very interesting. So here we have Section 1.1. A married woman shall, in accordance with the provisions of this Act, be capable of acquiring, holding, and disposing by will or otherwise of any real or personal property as her separate property in the same manner as if she were a femme sole without the intervention of a trustee. Now, what is interesting about this particular provision is the insistence on separate property. It would have been much simpler and easier and perhaps more progressive to actually say that marriage gave married women no entitlements or created no further impediments than what they would have if they were unmarried. So what happened here was the word separate property enabled the control of married women's property to be maintained by men. Because who were the continuing arbiters of what was separate? It was the male judiciary, and clearly at that point in time it wasn't very diverse. And also what we see here is it shows the fear and the hesitancy of the clearly male-dominated House of Parliament at the time, because they realised that property confers power and territory. And by granting married women property in the truest and fullest sense, you're enabling wives to change the power dynamics or challenge the power dynamics of marriage. Now, this use of separate property as a term of art to police married women's entitlement created, however, a cruel irony in my mind. And the reason being is tucked away, hidden within this particular act, is a Trojan Horse. And that, as many of you might have come across, is an entity called Section 17, which can be abbreviated as follows. It is an interesting provision, desperately crying out for full stops and punctuation, but essentially it's saying that whenever there is a question between husband and wife as to the title or possession of property, then a judge of the High Court may make such order with respect to the property in dispute and to the cost and consequence of the application as he thinks fit. As he thinks fit is one of the most important terms in this particular area and has been weaponized and capitalized upon by judiciary since. Now, it's a cruel irony to my mind, because within an act that was heralded as creating separate property, you actually had created a forum in which the idea of sharing property could be discussed by the courts. And here we see the 20th century, the marriage service invoked again. And this was used to criticize the inconsistency of the law, but in a fundamentally different way to the way in which the marriage ceremony in the Book of Common Prayer was used as a criticism in the Victorian period. Now, in a presidential address of the Holdsworth Club by Sir Jocelyn Simon, delivered in 1964, he opens with the following words, and I'll read them in full because I like them so much. He opens his lecture by saying, "I invite you to accompany me to a village church where a wedding is in progress. The mellifluous cadences of the vicar's voice fall hypnotically on the ear. Honourable estate, mutual society, help and comfort, comfort her, honour and keep her. Now he has reached the ceremony of the ring. The bridegroom bends a gaze of ineffable tenderness on his bride. With this ring, with my body, and with all my worldly goods I thee endow. I hold my breath aghast. Will the vicar rend his cassock? Will he sprinkle on his head ashes from the ancient coke stove? Will he hurl the bridegroom from the chancel steps with imprecation and anathema?" And he continues to say the following: "For that man has committed the most horrible blasphemy in that holy place, at this most solemn moment, actually invoking the names of the deity. He has made a declaration that is utterly false. He is not endowing the bride with a penny, a stick, a clod, nor does he ever intend to do so. And yet the service proceeds as if nothing untoward has happened." At the end of this particular lecture, he then juxtaposed this particular heresy with what would happen in France through the community of property regimes that they have there. And what he does is end by noting that in 1927, the Book of Common Prayer was actually amended so that "with all my worldly goods I thee endow" was changed to "all my worldly goods with thee I share." But then he was puzzled by saying, well, how's that happening? And he called upon lawyers to actually create sharing within marriage. Now, what's interesting here is that Francis Power Cobb's criticism of the wedding service in the Victorian period related to how the wife was ultimately endowing the husband with her property. Yet Simon's account sees the husband giving the wife nothing, not a penny, a stick, a clod. And that was over a century later in 1964. So where does Section 17 of the Married Women's Property Act come in? So Murphy and Clark have talked about how the inception of this particular provision, the history behind it, is regrettably obscure. What they argue, though, is that the provision was clearly intended as a procedural mechanism for judges to determine in a summary manner what property could be deemed as separate. It was there for certain simple questions to be answered. And Stephen Cretney, the legal historian, noted this quite clearly by noting that Section 17 was modelled on Section 9 of the 1870 Act. And that provision allowed for a summary mechanism for judges to declare which property should be treated as separate under the 1870 regime. Now, in the aftermath of the 1882 Act, And through most of the 20th century, it should be recalled that there is no wonderful luxury discretion that we have currently under the Matrimonial Causes Act. Prior to the Matrimonial Proceedings and Property Act, 1970, what happened is that spouses had to determine ownership using trusts, property, and contract. And the most common claim to ownership by a wife as to the matrimonial home came through the resulting trust triggered by a financial contribution to its purchase. This was before the fun of common intention constructive trusts that we're clearly dealing with today. Now, through the conduit of Section 17, what we see here is the true legacy of the 1882 Act, because this particular section and the fact it was used so often and it was so heavily litigated actually forced judges to confront what property holding within marriage looked like. It was also a controversial argument to make for women too, because the women's movement had campaigned and argued so vociferously for separate property that now they were arguing that marriage actually does involve a bit of sharing. Now, this is also in full knowledge that sharing would work both ways and that a husband would also have a claim to their property. So what we see here is one of the difficulties with using equality and equality measures, because equality involved the creation of separate property, but equally equality can be used to justify the sharing of the fruits of the marital partnership. Now, unsurprisingly, there are some early interpretations of Section 17 that raised a few eyebrows. One case was Hutchinson and Hutchinson, and it concerned possession of a house that belonged to the husband. He lived in that property with his wife and their disabled child. The husband had an affair and wanted the wife to divorce him, saying to her that I'll give you the house if you actually give me my freedom. She refused, and at first instance it was clear that the house belonged to the husband. It then goes to Judge Denning in the King's Bench Division, and he refused to grant the husband possession on the basis of Section 17. He said that this particular provision enabled a judge to make any order as he thinks fit. It gives the judge a free hand. However, it must be exercised judicially, whatever that means. Now, later, writing extrajudicially in the books that Denning wrote, in Due Process of Law, he reflects upon his approach to hearing this case and remarks, I could see here there was an injustice. It cried aloud for a remedy. I could see that was of first importance. So I decided not to give the judgment in chambers, where it would not be reported, but to give it in open court, where it could be reported. Students beware, I did not cite a single case. I dealt with it simply on principle. He then ruefully laments that despite his high hopes that he was going to create a game-changing decision, that it was missed by the regular series of law reports. Now, undeterred and feeling more determined as a senior judge, he then developed Section 17 and its discretion in a much more elaborate manner in a case called Hine and Hine. And this was really the high water mark for its interpretation. What we see here was a dispute over a jointly owned matrimonial home that had been acquired with contributions made by both parties. The wife used Section 17 as a means of determining the proceeds of sale. And here, Lord Denning, as Master of the Rolls then, said that Section 17 was entirely discretionary. Its discretion transcends all rights, legal or equitable, and enables the court to make such orders as it thinks fit. Now, it's perhaps unsurprising that this interpretation of Section 17 was comprehensively rejected in National Provincial Bank in Ainsworth in 1965, and then later in Pettit and Pettit by the House of Lords in 1969. In that particular case, we had the House of Lords saying that Section 17 was procedural only. So this meant that Mr. Pettit, who did lots of DIY jobs around the house, including building an ornamental well, was unable to actually claim a share in the ownership of the cottage, Tinker's Row, that he lived in with his wife, Hilda Pettit. Now, for me, prior to Pettit and Pettit in 1969, the significance of Section 17 is that we had 20 years of an industrious court of appeal exploring property holding within marriage. You can dismiss Hine, you can dismiss Appleton and other cases that stretched Section 17 to its fullest. But what we see is really the courts going against the superannuated traditionalism of resulting trusts and thinking a little bit more creatively. So in Ray Rogers' question in 1948, you had the court soften their focus on the intention of the contributor for a resulting trust. And then this was further developed in 1952 in a case called Rimmer and Rimmer. Now, here you had property that was purchased in the name of the husband, but with financial contributions made by the wife. He was responsible for the mortgage, and then following deployment to the merchant service, the wife supplemented the mortgage repayments with her own earnings. Taking advantage of a post-World War II boom in property prices, the property quadrupled. And in the county court, the husband pocketed all the windfall through the standard mathematical application of resulting trust principles. You get what you paid for. Now, in the Court of Appeal, the proceeds were actually divided equally. Evershed, Master of the Rolls in Rimmer, he was also in Ray Rogers' question in 1948, said that this was another case of the courts having to try and do justice under Section 17. But drawing upon some of the personal property cases, where you have money in a bank account, in particular Jones and Maynard, he says we should think about the equitable maxim of equity delighteth in equality. And so if the intentions of the parties can't be discerned, then in Rimmer, equality almost necessarily follows. Now, there was, of course, criticism of this interpretation, particularly if we remember that Lord Denning was actually in Rimmer and Rimmer, and again, extrajudicially, and in his typical self-congratulatory manner, he remarked how the Court of Appeal struck out on a new line, and we knew we were doing it. But irrespective of the scope of the discretion conferred by Section 17, the courts were again having to navigate the dynamics of marriage, the property holdings of parties in marriage, and also having to value different contributions made by spouses to a marriage. Now, out of Rimmer came the idea that if both parties had a beneficial interest in the matrimonial home, and if it was not possible or right to give effect to precise shares, then the potential arose for equal division. Cases later, such as Freebents and Freebents in 1957, developed that further. And what we see there is a development of the family assets doctrine. And at the peak, the Court of Appeal in Gissing and Gissing talked about the family doctrine in the following way. It basically enabled a claim for a spouse to share property, irrespective in whose name it stands, or who pays for what, or who goes out to work, or who stays at home. Now, we will obviously be aware of Section 17 and this interpretation of family assets being utterly scotched by the House of Lords in Pettit and Pettit. Lord Morris said here that the whole point of the 1882 Act was to give the potential of separate property. There was no suggestion that the status of marriage was to result in any form of common ownership or co-ownership of property. Now, with those observations and in the House of Lords crushing of all of the developments of the Court of Appeal in 1969, we see all the chances of judicial development in this area evaporating. And so Parliament had to reform the area of law, and it did so with the Matrimonial Proceedings and Property Act. And I always think of Valerie Gissing, who, if only she'd waited for a few months, could have actually availed herself of this later act and have her assets divided in a totally different way. Now, I'd like to finish by thinking about the contribution of the 1882 Act to the modern law. We see quite interestingly an observation by Lord Reid in Pettit. And he said it would be incredible that any parliament of that era could have intended to put a husband's property at the hazard of the unfettered discretion of a judge. Now, I would love to know what Lord Reid would actually make of today's approach under the Matrimonial Causes Act 1973. Now, what we know quite clearly from Lady Hale and Radmack and Granatino is that separate property is the basis of our matrimonial property regime. It's the way in which we hold assets today. However, as many of you will be aware, we have this separate property tempered by an extensive and expansive and almost luxury judicial discretion under the MCA. And we see this also quite clearly through how that discretion has been interpreted by the House of Lords, notably in White and White, where you had Lord Nichols having to engage with the idea of equality as an aspiration with equality as a result. Now, in this particular case, we have a lengthy marriage of 33 years, a married couple who had a farming business together. Their children had grown up, so were not really relevant for the application of the Act. Their marriage broke down, and separate property meant that Pamela White was limited to her reasonable requirements, and that was exactly what she was given at first instance. The award of 17% was then increased by the Court of Appeal to recognise her contributions to the marriage, notably through the intervention of Lady Justice Butler Sloss at that time, noting the important contribution that she had made to the farming business. Now, what's more interesting for me and our understanding of equality is how Lord Nicholl's reasoning developed. He rejects reasonable requirements and then creates a principle of equality, an aspirational principle of equality, which is non-discrimination, that there shall be no discrimination between the breadwinner and the homemaker. There is no place for discrimination between husband and wife in their respective roles. And then this is linked inextricably to the yardstick of equality. So before reaching a firm conclusion and making an order along these lines, a judge would be well advised to check his tentative views against the yardstick of equality of division. As a general guide, equality should be departed from only if and to the extent that there is good reason to do so. Now, whilst this is clearly laudable in terms of its aims, it does raise multiple questions as how such an open-textured understanding or principle of equality can actually be realised in practice. And also we need to remember that Pamela White didn't actually get half, much to her dismay, and as she said to the press. The reason being that the husband's father's contribution to the acquisition of property was a non-matrimonial contribution, which was then able to displace the sharing principle. Now, 20 years on from White, are we any further? And questions abound really as to the meaning of equality in the division of assets today. So, first of all, I want to question, in a legal taxonomic sense, what on earth is the yardstick? Is it a presumption? Is it a principle? Is it a referencing tool? To what assets does the sharing principle apply, and how is that altered when we think about the length of the marriage? How does the principle of sharing operate alongside the other strands identified in Miller and McFarlane, namely needs and compensation? We thought compensation had gone away, only for a few weeks ago it seemed to have resurfaced. Also, if we wanted a sharing principle, might it not have been better to create one explicitly alongside a coherent rationale underpinning it? As Judge Elizabeth Cook notes, we have a yardstick which is a very bendy stick. And also, was White the right case to create a sharing principle? Because it was so much linked to the fact that it was a farming partnership. She wasn't just a wife, she was truly a business partner. And also, is it right for us to have a sharing principle in the law with actually no cast iron ability to reject the sharing principle using a marriage contract or a prenuptial agreement? Now, I certainly can't provide all the answers, and the judiciary are really doing their best on a daily basis, having to navigate these issues. But it does make me wonder, in light of what I've said about Section 17 and the litigation prior to 1971, whether equality can really be recognised and respected within such a discretionary regime. We also see, an area closer to my research, the legacy of Section 17 being discussed in disputes between cohabitants. But we see, quite sadly, Section 17, which I obviously have a very strong fondness for, being somewhat viewed as palm tree justice. It's seen as this pejorative provision. Now, in Stack and Dowden, Section 17 was discussed, and it was viewed interchangeably with the idea of palm tree justice. And attempts then to use fairness in the quantum of a constructive trust were actually deemed impermissible in the House of Lords decision, but only then to be found permissible 4 years later in the Supreme Court decision of Jones and Kernot. So where does this leave us then today? Now, one thing thinking about International Women's Day and the contribution that we have when it comes to celebrations of equality, I was really taken by this quote by Susan Staves about how legal history has most often been celebratory, explaining how the law has more and more beautifully adapted to the needs of society, more and more perfectly reflective of absolute justice. And we see that today in all the celebrations that we have of the movements across the globe, particularly yesterday for International Women's Day, as to equality measures and where we need to go. So these celebrations of equality are incredibly powerful, and we have to memorialise these events and talk about them. But hopefully through this lecture, I've made you think a little bit more about the darker side of equality and the fact that we have to consider how we actually translate equality from an aspiration into something that is tangible, and whether something that we bill as an equality measure actually needs to be interrogated a little bit further to check whether or not behind those benign intentions that are often trumpeted, that behind them we have actually structural discrimination. Thank you.
Well, thank you, Dr. Hayward, for being such a masterly guide to the last 100 years or so along what appears to have been a very winding and rather bumpy road from a biblical concept of women's rights in marriage and property to a concept based more on equality. But it looks as if perhaps there's more twists and turns to come. Now, does anybody have any questions? If you'd like to raise your hand, if you'd like to ask any questions. It looks as if you've answered everybody's questions, so thank you again.